The most important law is the law of justification. Justification is our legislature saying, ordinarily it's a bad thing to shoot somebody in the face, but in this case, under these circumstances, you get a pass. That is what this is all about in Title 17A, is getting that pass. There's some very important principles. The criminal code is designed sort of like basic training in the military. It's designed by geniuses for idiots. It's pretty simply organized. We talk about defense of persons, that's Section 108. Places, that's Section 104. Stuff, that's Section 105. And use of force in law enforcement, which really isn't defense at all, in Section 107. There's some general principles in Section 101 at the very beginning of the chapter. And there's some definitions at the very beginning of the whole title in Section 2. So let's start. The most important thing that I've told you about is Section 108. And the most important part of Section 108 is what I call self or innocent other defense. And the law says this. Let me read it to you because the words are important. A person is justified, we know what that means, in using deadly force, and that has a particular meaning, upon another person when the person reasonably believes it necessary. That means based on facts that you can see there on the ground, you think there's no other way you can get out of it. And you reasonably believe such other person is about to use, that means right now, not next week, not I'm going to come over to your house later on, about to use unlawful, deadly force against you or a third person. That's classic self or innocent other defense. They say unlawful force because if somebody's justified in shooting you because you're shooting at them, that's okay. They can shoot you. Don't do bad stuff. Don't break into houses. Don't put other people in fear of their lives. Because if you do, they will be justified under this section that I just read you. That's probably the most important section in the criminal code. Now, deadly force is not necessarily what you think. If you look in Section 2 of the criminal code, where most of the definitions are, you'll see that deadly force is that degree of force which, used in the manner intended, is likely to cause death or serious bodily injury. And serious bodily injury includes a lot of stuff that's not death. It includes permanent disfigurement. It includes substantial harm to a bodily member or organ. And it also includes, and this is probably the most vague one, but likelihood of putting you, what is the term they use? Extended convalescence necessary for the recovery of physical health. In short, if somebody's going to put you in the hospital for a long time, the classic leg breakers from the mob, that's deadly force, even though it probably won't kill you. The flip side is this. If you threaten somebody with putting them in the hospital for a long time, or serious permanent disfigurement, or permanent serious damage to a bodily member or organ, you've just threatened them with deadly force, and they might be justified in hurting you. The law that I teach you has two uses. One, to keep you out of trouble with the law, and second, to make sure you don't get justifiably injured or killed by your fellow citizens from being an idiot. Now, why do we need to know about non-deadly force? Because anytime you shoot a firearm at somebody or in their direction, by statute, that's deadly force. There's an exception for people like corrections officers or cops using our new toys that launch beanbags and things like that out of firearms. But for everybody else, for all the rest of you out there that are taking this course, if you shoot at somebody or in their direction, intentionally or recklessly, that's deadly force. Recklessly can happen if you know there's a risk that somebody's out there and you shoot anyway. Classic example is in the woods when you're hunting. Maybe it is deer season and maybe there's a deer right there, But if you hear voices in the woods beyond that deer and you shoot, guess what? You've just probably used deadly force on the people that are likely in the woods, and they're probably entitled to shoot back. What else is there besides the classic self or innocent other defense? Well, there are 3 crimes that are specifically mentioned that you can use deadly force if you reasonably believe it's necessary to stop. And you're going to need to know where to find those in the criminal code. I'll tell you where it is later on. Those 3 crimes are robbery, kidnapping, or a violation of Section 253, subsection 1, paragraph A. And that has to be bad because they don't even tell you what it is. It's actually forcible gross sexual assault, and yes, it is bad. So I've asked a former head of the criminal division, who's now a judge, whether that means you have to believe that unless you use the force that you'll get hurt, or does it mean that unless you use the force, they will succeed in the act? In other words, if it's a robbery, that they'll get away with the stuff that they're trying to steal by the use of force. He said it's the last one, that if you're afraid that they'll get away with it, that's good enough. What is robbery? Robbery is not theft. Theft is taking something that's not yours. Robbery is taking something that's not yours by the use of force or the threatened use of force, or where you actually stupidly, recklessly is the word they use, hurt somebody in the process. There are a bunch of ways that it can happen, and it doesn't have to be against you. For example, if somebody's kid was in a store and I walked up to the kid and said, I'm going to crush this young man's neck unless you give me your wallet, it's a robbery. It's a robbery vis-a-vis you, even though I haven't threatened you. Kidnapping is another combination crime. It's criminal restraint to accomplish one of a number of goals that they set forth in the kidnapping statute that's also there in Title 17A. Generally, it involves holding somebody for ransom, using them as a hostage or shield, taking them someplace to either inflict bodily injury on them. That doesn't require much. Fraternity hazing is probably bodily injury. If it causes somebody any pain, it's bodily injury under Maine law. And then there's some more weird stuff. Apparently, you can kidnap somebody by threatening to destroy or taking their immigration documents. The odd consequence of that, and it probably never happens, is that you could end up shot for threatening to burn somebody's passport. I toss that out there just because it's there, not because it's likely to happen to you. And forcible gross sexual assault. Gross sexual assault is a sex act done via compulsion. Sex act is more than the standard sexual intercourse, penis and vagina. It can be done a lot of ways, involving genitals or anus of a person, or an object being used by another person, and God help us, I don't know why our legislature put it in there, an animal being used by another person. It's there. And it has to be by compulsion, which can be either force, which can be non-injurious force. If you're bigger enough than somebody and you hold them down and you make them do it, that's compulsion. If you threaten them or threaten somebody else, that's also compulsion. So forcible gross sexual assault by compulsion is something that you can use deadly force to stop. Now, with all of the things I've just mentioned, you can't always use deadly force. Just because you're being threatened with deadly force doesn't mean that you automatically get to use deadly force to stop it. Let me give you an example. 3 people involved. Person A is a weak, old, 85-year-old woman in a wheelchair. Person B is a 13-year-old, mentally ill young man who wants to rape and kill her. Person C is a weightlifter who comes on the scene. Now, most of these statutes say that you're justified in using deadly force if you reasonably believe it necessary. Well, the lady in the wheelchair is not going to be able to resist the 13-year-old kid. He's not a bruiser, but she is infirm and weak and can't even stand up on her own. He can and probably will be able to kill her with his bare hands. That's the other interesting thing. Deadly force does not require that you have a weapon. You can inflict deadly force on somebody barehanded or with any kind of an implement, so long as it is sufficient to cause death or serious bodily injury in the way it's being used. She can shoot the young man if she reasonably believes that if she could simply get out of the way or something. If it's in her home, she doesn't have to. But she's probably going to be able to shoot him just fine. And no jury in the world will convict her. No prosecutor will bring it. She will be justified. How about the weightlifter walking into the door, seeing it going down in front of him? Can he shoot the young man? He doesn't need to. He can just pick him up by the scruff of the neck, smack him gently against the wall a couple of times to soften him up, and hold him against the wall and wait for the police to arrive. He doesn't need to cause death or serious bodily injury to that young man to stop that crime. So here's the interesting paradox about deadly force. It depends who you are and what you bring to the table in terms of whether you're justified in using it, whether you reasonably believe you're justified in using it. Now, reasonable belief is something I ought to explain here now too. You see it a lot. And it doesn't mean you have to be right. It means two words. Belief means you have to think it. Reasonable means that it has to be logical based on stuff you could see or hear or that you know from reasonably reliable sources. If somebody reaches into their coat like this and says, I have a gun and I'm going to shoot you, well, at that point in time, unless the coat's a transparent raincoat and you can see it right in there, it's reasonable. It could be. And if it could be, and they've said it is, the law says you can treat it as real. Where else can you use deadly force under Section 108? Well, we've got self or innocent other defense, the three crimes, forcible gross sexual assault, robbery I haven't touched on much, and kidnapping. And then we have what I call a noogie in your home. You've probably heard people say a lot that you need to be in fear for your life to use deadly force, and certainly nobody's going to give you a very hard time if that was true and you felt that you had to use deadly force, shoot somebody to get out of it. But in your home, the law is different in Maine. It says that if a person reasonably believes that another person has entered or is attempting to enter, remember, drag them inside, if they're trying to get in, this law applies. They don't have to be inside yet. To enter a dwelling place, or that they've surreptitiously remained in a dwelling place, a place where people live, a place with bedrooms that's set up for overnight accommodation of people, and that deadly force is necessary to prevent the infliction of bodily injury by the intruder upon the person or a third person present in the dwelling place. Now, that's interesting. Bodily injury can be any pain, any impairment of physical condition. So the first part of Section 108 says, boy, to use that, you have to reasonably believe that you're going to be killed or seriously injured. This one says, in a dwelling, from an intruder, all you have to think that'll happen is somebody's going to get a little injured if I don't shoot. I know there's a moral component here. That's a case where the weightlifter probably could shoot the 13-year-old kid if he thought he'd get one lick in. The explanation is our legislature has decided that intruders shouldn't be allowed to injure people, and that people that live in houses and in homes shouldn't have to wait in fear for what ultimately transpires before defending themselves. The onus is upon the intruder, the burglar, to not hurt people. And if you think you're going to be hurt at all, and you think that deadly force is the only way you can prevent you or somebody else from being hurt in a home at all, the law says you can use deadly force. There's a few limits in Section 108. One of them is Provocation. If you wind somebody up to attack you and then you shoot them dead, you're not justified. Provocation negates justification. If you can, with complete safety, retreat from the encounter under 108, you can't use deadly force yet. It doesn't say you have to retreat, but you can't shoot. If you can retreat safely, you can't shoot. You don't have to retreat in your own home. Under Section 108, that's not required. If you can surrender property in complete safety to somebody who is asserting a colorable claim of right, somebody who has some kind of ownership, the repo man and your car, if it's got paper on it, that's a person that has a colorable claim of right. Don't shoot the repo man. On the other hand, if the repo man pulls a gun on you, you can't exactly surrender it in complete safety. There's this final thing at the end. It says if you can comply with the demand that you abstain from performing an act you're not obliged to perform, that's what it really says, then that's what you've got to do. No one knows what it means, but it's there. So that's Section 108, use of force in defense of a person. So what's the next one we typically encounter? The next one we typically encounter is Section 104, use of force in defense of premises. There are two typical things that we encounter there in terms of justifications for the use of deadly force. The first is arson. Some kind of an occupant of premises, you have to be an occupant, and premises can be buildings, lands, private ways. The definition is very broad. It doesn't have to be inside a place. If you're out in the middle of a field, that's premises. If you're an occupant of premises, you can use deadly force if you reasonably believe it necessary to prevent an attempt by somebody else to commit an arson. Now, if you're not an occupant, it doesn't count. If they've already started the fire, it doesn't count. But under a very limited set of circumstances, you can do that. By the way, arson is defined as either somebody setting or maintaining a fire or explosion on the property of another, or burning down or blowing up their own property that's right next to yours, and it's going to burn down or blow up your property too. And they're doing it for insurance proceeds. So that's only happened once that I'm aware of in the state of Maine, where somebody was shot because they were attempting to commit an arson. The other one is what we more commonly encounter, which is getting the burglar out of the house. And it doesn't require specifically that anybody be about to be hurt at all. If it's defense of a person, that's 108, and that's a different set of standards. Under Section 104, a person in possession or control of a dwelling place or some other kind of lawful occupant of a dwelling place can use deadly force to prevent, that means they haven't got in yet, or terminate the commission of a criminal trespass. And by the way, this is necessary to be a dwelling place. That's a structure where people live. It might include a houseboat. It might include some kind of an RV where people sleep. The touchstone is there has to be a place where people can overnight in it. If it's got a bedroll in it, a tent can be a dwelling. The most elaborate store in the world that isn't set up for overnight accommodations is not a dwelling. And parts of a place can be a dwelling when parts aren't. Any hotel you've ever been to, the whole front lobby area is not a dwelling place. We've got some case law that says that. So, and also garages and attached structures aren't the dwelling place. It only starts on the footprint of the house itself. So, it deals with intruders, people that haven't been invited in. If they've been invited in, you can turn them into trespassers, but this specifically doesn't apply to them. It deals with people that have entered or are attempting to enter the dwelling place or have surreptitiously remained within without a license or privilege to do so, meaning they know that they haven't been invited to be there. I talked about flip sides for the rest of us, how to avoid getting shot. You can commit a criminal trespass in the state of Maine by entering any dwelling place knowing you're not licensed or privileged to do so. Doesn't matter if the door's open or shut, locked or unlocked, or if there's no door at all. don't go into people's houses without being invited unless you've got a warrant. So, if they're an intruder, they're entering without a dwelling place without license or privilege to do so, you're some kind of occupant, and they're committing or are likely to commit some other crime when they get in there, and you have reason to believe that, you can use deadly force if you reasonably believe it necessary to get them out. There's a couple of provisos, though. First, you have to reasonably believe it necessary. If a 12-year-old kid has broken into your house and he's smashing stuff or stealing something, and you're a 6'5" weightlifter and he doesn't have a weapon, you ought not to be shooting him. Again, grab him by the scruff of the neck, shake him up a little bit to soften him up gently, and hold him for the police. Or throw him out. But you don't reasonably believe you need to shoot that kid to stop that trespass. Again, the smaller you are and the bigger he is, or the more stuff he has with him, the more likely it is that the law will support your decision to use deadly force to get him out. But you can't use deadly force under Section 104 unless you first demand, and this is the words of the statute, you have to first demand that the person against whom the deadly force is to be used to terminate the criminal trespass. Yeah, imagine saying, terminate the criminal trespass. Let me tell you, unless he's graduated from high school, he's probably not going to know what that means. Tell him, get out or I'll shoot. And if he fails to immediately comply with the demand, and he's bigger than you, or he's got a weapon, now you're starting to talk a shoot situation. You don't always have to give that demand. If you reasonably believe, based on stuff that you see in here, that it would be dangerous to you or another to give that demand, then you don't have to. So those are the two situations that you can use deadly force in defense of premises. You can use deadly force to eject a trespasser that is in fact an intruder, like in Section 108, somebody that hasn't been invited in, or to prevent an arson if you're an occupant. How about stuff? Are you allowed to use deadly force to protect your stuff? You aren't, not in Maine. There is a statute, Section 105, use of force in property offenses. And it says, you're justified in using a reasonable degree of non-deadly force on another person when and to the extent that means, you got to stop if it works. You reasonably believe it necessary to stop what is or reasonably appears to be an unlawful taking of your property, or criminal mischief, that's wrecking your property, or to retake your property immediately after its taking. If you chase right after somebody who's just stolen your stuff, you can wrestle with them, punch them in the nose, break 1 or up to 5 fingers probably, stuff that you would typically do that won't put them in the hospital forever, that'll get your stuff back. But you can't shoot him. You can't shoot somebody just to get stuff back in the state of Maine. You can only use deadly force per 107, 104, and 108. I've talked a little bit about use of force in law enforcement, and surprisingly to everybody, there are actually a couple of scenarios where that can happen. One is where a cop tells you that you should shoot somebody, and you believe the cop could do it. Now, the word reasonable belief isn't there. If he's a cop, and he says shoot him, and you know he's a cop, I do think he has to actually be a cop. Okay, he says shoot him, you can shoot him. Cops actually have to have reasonable belief to shoot somebody. All you have to know is he's a cop. The other area that the law talks about using deadly force is when I'm telling you, don't ever do it. That's to effect a citizen's arrest. A citizen's arrest is an arrest that you make based on your authority as a citizen. There's magic words you have to say. There's stuff you have to do. The person has to be aware that you're a citizen attempting to effect a citizen's arrest. It's really hard, and you have to know what the element of crimes are. And you have to be right. All that reasonable belief stuff is out the window. The words are in fact. All the stuff has to be in fact true, which means if you're wrong, even if it's somebody's identical twin, you go to jail for life, even though it was a reasonable mistake. So if the only thing that's going to happen is somebody's going to get away, nobody's going to get hurt, no stuff's going to be taken, none of that's going to happen, let him go. The only reason to shoot him would be a citizen's arrest, and that's too dangerous for you legally. But what about non-deadly force? Well, under Maine law, the threatened use of deadly force is considered to be the equivalent of non-deadly force. It's justified according to the same principles. A few years ago, our Maine Supreme Court faced this and realized, boy, it would be really good if people could just threaten each other and end a situation, and there was actually a standard for that. The standard wasn't really clearly set out, and so they basically said threatened use of deadly force is the equivalent of non-deadly force. And you'll need a lot less to justify non-deadly force. For example, there's a whole bunch of extra stuff if you're going to get a trespasser out of a dwelling. However, you can use a reasonable degree of non-deadly force to the extent that it's necessary to remove a trespasser from premises. And somebody can become a trespasser in a public place if there's a reason to exclude them and they're in there, and they're told to leave by somebody in authority. And if they don't leave, you can use as much force as you need to, short of badly injuring them, to get them out. If they start coming right off, that means you'd only be able to pull their arm. How does this apply to firearms? Well, if you say you have a firearm, I'm going to shoot you unless you leave. Or you display a firearm and say, you better leave. Or if you ready the firearm and say, I'm going to shoot you unless you leave, those are all ways that you can threaten the use of deadly force. It's all non-deadly force, but non-deadly force has degrees. There are no degrees of deadly force. It's all good against the person that you're threatening. It doesn't matter what you do to them. If you're justified in shooting them, you're justified in vaporizing them, cutting them in half with a guillotine, sicking wolves on them, it's all good. But non-deadly force, the degree has to be justified as well. Because there are degrees of non-deadly force, there are different ways you can threaten somebody, and it will make the speedometer go farther towards 100 than 0. Simply indicating, I have a firearm, I'll shoot you, is a less degree of threat than actually pointing it at somebody and telling them that you'll shoot them. There's an additional problem with that. It better be a really justified circumstance, because if the firearm goes off when it's pointed at somebody, they're going to be injured or killed. And it better be justified. That's really something you should reserve for a gray area where deadly force might be justified, because our Maine Supreme Court has held that if, absent justification, merely pointing a gun at another person is enough to convict somebody of reckless conduct with the use of a firearm, a felony. What are some of the other restrictions on the use of deadly force? Well, there's a couple. The most important of which is the duty of care you use to people you're not trying to shoot. We don't always have the luxury of having bad guys nicely isolated against a worthy and thick backstop with no other innocent people around. School shootings and mall shootings and things like that happen with bystanders. And that's been a very thorny issue, and our statutes actually address it. I've once again asked the AG's office about it, and this is basically what they say. The standard is that if you are justified in shooting somebody, but you recklessly injure or create a risk of injury to somebody else, that justification for shooting the bad guy doesn't apply to shooting the good guy, or even creating the risk of harm. But the problem is in a melee situation where there's good people and the bad guys in the middle shooting and shooting, doesn't that mean you can never shoot? Well, the weasel words are in the legal definition of recklessly, which is, for you wonks out there, it's in section 35 of the Criminal Code. And it excludes, it says, in examining whether something is done recklessly, you consider the nature and purpose of the person's conduct. If it's to get somebody out of your house that isn't injuring or killing somebody, that's not very good justification for shooting somebody else. On the other hand, if the bad guy is an active shooter and every minute that goes on he's shooting somebody else and continuing to shoot, you know that if you don't shoot, more people will die. Maybe somebody would be hurt. Maybe your bullet would go through the bad guy and hurt a good guy. But if you do nothing, he's going to keep killing people and get around to you. I've asked a former Deputy Attorney General if that's what he thinks it means, and he said yes. I think we can go to the bank on that. By the way, the feds have a standard that'll curl your hair. They don't need no stinking badges. They believe that they can shoot through innocent people to get the bad guy. And there's circumstances where that might even save lives, but don't do it. Let's talk about a few other things that you can do to get you in trouble under, more justifications first. I've talked about justification for shooting people. How about dogs? There is a section in Title VII that specifically deals with dangerous dogs. It's hundreds of years old, and actually a couple hundred in its origin. And it says, any person may kill a dog if necessary to protect the person, another person, or a domesticated animal in the course of a sudden, unprovoked assault. One sentence. Kill is the word they use. It has to be a sudden, unprovoked assault. If your kitty cat scratches the dog and it retaliates, that's not an unprovoked assault. The big question is, if you cross across somebody else's land and their dog is trained to protect that land, is that an unprovoked assault, or are you provoking the dog? Don't go across people's land without asking, and you'll never have to pay me $10,000 to find out the answer to that question. So you can shoot dogs to protect you, and there's no comparative analysis as to cost. If they're a $10,000 Rottweiler attacking your pound kitty cat, if it's a sudden unprovoked assault, sheep, horses, domesticated animals, you can kill them. Wild animals, there's a statute in the justification provision called the competing harms defense. It says where if the harm that is, first it only applies when it's physical harm to people, not property. You're not allowed to protect property under Section 103 with these principles. But if some person is going to be physically damaged, hurt, or killed, and the interests served by the statute that you're violating are less than the value of human life, basically, you're allowed to do that which would otherwise be illegal. If you're freezing to death out in the woods, you can break into somebody's camp and start a fire and call using the phone and make yourself a meal. If somebody's hurt, you can tear up somebody's awning to make bandages. And the other example is, if you're attacked by a wild animal, then to protect yourself or to protect somebody else from a wild animal killing you or badly injuring you, you can shoot the wild animal. There's an exclusion in there for problems you get yourself into. If the wild animal that attacks you is in the gray animal farm and you've climbed over the fence to get a closer look at the bear, don't think that Section 103 is going to get you out of trouble. Then in Title 12, there are a couple more statutes that deal with animals causing damage to crops, to other domesticated animals. It's a pretty easy statute to understand. You have to immediately, when you invoke the statute, you have to report to the game wardens that you've done it immediately. It has to be the game wardens. Interestingly, all cops in Maine have the powers of a game warden, but it says game wardens. Be safe. Look up the number and call IF&W. These are wildlife caught in the act of damage to crops, to domesticated animals, damaging property. However, there are certain animals that it doesn't apply to. I call these the tasty animals. Deer, bear, beavers, and birds other than doves, rock doves, and wild turkeys. Those there's special rules for. And if you've got those things damaging your property and not trying to kill you, you've got to call the wardens and let them deal with it.